who won a $140 million verdict for Hulk Hogan in his defamation lawsuit against Gawker Media, is now representing Melania Trump in her fight against news outlets that publish parts from a book called From the Whorehouse to the White House, The True Story of Melania Trump. For further insight, we're joined by business and civil litigation attorney Walid Tamari. Welcome, Walid.
Hi, how are you?
The Daily Mail also said there is no evidence to back these startling claims made in Susie magazine and these other articles. So I have to ask, is it defamatory if a media outlet is quoting a different and separate publication altogether?
Well, again, it doesn't matter where the publication or the news outlet obtained these, what sources they had. If a news outlet or any really defendant is going to publish statements that are false and defamatory, they could be liable. The threshold is, especially in this case, you're talking about a plaintiff that was, Mrs. Trump, who is a public figure. The threshold was this publication done with actual malice. That's the standard. Okay.
So what's the difference if you're a public figure versus a private citizen who is suing for defamation and libel?
That's a great question. So what is the difference? The difference is, there in the United States, there has to be a balance generally between freedom of speech and protecting somebody's reputation. So the standards that the courts over the years have developed is as follows. If you are a public figure, you have to prove that the defendant published, communicated the false defamatory statement with actual malice or with a total reckless disregard for the truth. That's the standard.
Okay. So it's probably easier if you're a private citizen to prove some type of negligence?
That's exactly what you have to prove if you are a private citizen. If you're a private figure, then it's a negligence standard. That's what it is.
Okay. So from a PR standpoint, does fighting this give these claims any type of credence? Is it worse that she's fighting it if it is true, these Johns could come forward?
Well, it's first of all, the attorney, as you mentioned, the attorney that wrote the letter, there was a demand letter that was written by Charles Harder. Charles Harder is Melania Trump's attorney. He basically wrote a cease and desist letter, and he's requesting a couple of things before we even get to litigation. The first thing he's requesting is that they retract all of these statements, and some of these news outlets have already done that. The second thing is that they permanently delete any type of publications or any type of publications of these stories from their outlets. And then number three, he also continues to expressly reserve all future rights.
To your second and third point, is that standard practice?
In a defamation situation, it is standard practice, absolutely. It's standard practice from a couple of perspectives. First of all, if you're a plaintiff and you feel you've been defamed, one of the things that plaintiffs want to do is they want to eliminate, they want to reduce the potential continued publication of these alleged defamatory statements. That's point number one. Point number two, you know how we've talked about this actual malice standard? So it goes to point number two, is that if there's a demand letter that was actually written and the publications continue, it gives the plaintiff an additional basis to argue that the continued publication is actual further evidence of actual malice.
I have to ask, how common is it for a public figure to do something like this? It has to be expensive to fight every single claim.
Obviously it could be expensive to fight every single claim. And again, a public figure has the threshold of a actual malice standard. So, it's a situation where I'm not sure if you're a plaintiff public figure, the goal is going to be to try to fight every single defamatory or potentially defamatory statement. I think you look at it on a case-by-case basis. And I think at the end of the day, what you do you're free to pursue all defamatory statements, but obviously you're going to target the defamatory statements that are really, in the plaintiff's opinion, very outrageous.
And again, the media outlet has to prove malice, and that's going to be hard to do. And at this point, it looks more like it might be profit over malice. Do you think that it's a coincidence that Trump said in February he plans to change libel laws in the U.S. so that he can have an easier time suing news organizations?
Well, I mean, it's interesting because if you look at this litigation, I mean, I think I don't know if you can actually draw a connection between those two. I think if you look at these, if you look at the timeline here, is that this publication, these publications where the alleged defamatory statements took place, they were recent publications. I mean, this was within the last week, and Charles Harder's letter, demand letter to these news outlets, really took place the beginning of this week. So I don't know if you can really definitively create that type of affiliation.
And he has had a very tumultuous relationship with the media. He's called them quite a few different things. So it would fit right in with his agenda. Walid, Tamari, thanks so much for weighing in tonight.
Thank you for having me. Thank you.